typically it goes to a straight foreclosure, right? It's
Usually,
more
yeah.
of a straight foreclosure play. They don't want to wait 12 months because obviously there's not going to be any debate about it. And Robin mentioned that'd be a good topic for us to bring up. But it's typically a foreclosure play, right? You're hoping that someone comes along and they work it out and they sell the property. But in the meantime, they're stuck in a situation where you're going to have to foreclose and go through the process because you have no one to deal with.
Yeah.
I think that
it's deceased borrower. You're pretty much always looking at a foreclosure, but maybe not.
Yeah. I mean, and again, maybe looking at it from an investment opportunity. If you're able to buy that first position at a discount and you're able to see if there's equity in that property, and then you can flip it and do something with it.
Yeah.
Maybe you arrange it in some way with that, and then you still stay first position.
Yeah.
Right.
Yeah. So like
one of the questions
are going to be popping up. A bunch of people are commenting on the Facebook feed. They love learning about reverse mortgages. So we'll definitely do a topic in the coming weeks. Sorry, go ahead.
So I had another question, sir. For the probate, who initiates that? Does it have to be an heir, or can I, as the lender, say, "Hey, Al, we want to take this through probate. Okay, go."
Yeah. So the beneficiaries are the ones that start that probate, right? It's the direct beneficiaries of the deceased. I've seen 2 times where a creditor was the one that initiated the probate, and it was because they wanted to try to get their money back. And I actually saw it 2 weeks ago where they initiated the probate themselves to try to get the money, but then the spouse ended up hiring a lawyer, and then the creditor withdrew their claim, their petition, because at that point, all they had to do was file a statement of claim, right? So I've seen that 1 or 2 times where, they could start it. But generally it's the heirs, it's the children, it's the spouse, it's maybe they don't want to be the ones to handle it, but they designate their uncle as being the one that is going to handle the probate, or maybe open it up.
But if we're dealing with people who may be in areas that are just not so involved, we can initiate that probate part. If we don't see any kind of record in the court saying that this has gone through probate and finalized, we can do that, right? We can start that process of doing it just to get it done, get it figured out who owns it, so that if we have to file any kind of paperwork on it, we know who the deed owner is, obviously, but we're filing on the borrower, but then we can name those people involved, I would think, correct?
Well, I'd say this, it's a security instrument, so it's going to come up on title too, right? So anything that you're doing is coming up on title. So making sure that mortgage is recorded, right? But let's just say you had a loan that was an unsecured loan. There's, creditors, they tend to file claims. So if they know that there's a probate open, they'll just file what they call like a statement of claim, and try to lock in their claim. But I've just rarely seen where the lender themselves, they're starting the probate, just because you can't get a property sold without going through the first position, second position, the recorded lien holders, right? So now if they're not selling it and then you're trying to get it back, maybe that's the angle, but I've just rarely seen it.
One more follow-up to that. If hypothetically, if I am the lender on a loan property in Florida, I initiate a probate just to kind of clean up the records and make sure that whoever's a potential heir is figured out one way or the other. If then I pursue that to foreclosure, can I recuperate the costs of doing the probate? I wonder if that's like a lender fee.
Yeah, like a corporate advance.
Yeah.
I've never thought about it that way. Nathan's getting creative.
Yeah.
But here's the other part. Oh, why go through a probate and foreclosure at the same time? Why not just do the foreclosure? You're not going to know who the heirs are anyway. Right. So the idea of probate also is to determine who all the heirs are. If you don't know who the heirs are anyway, why even go through that added expense when you can just bring a foreclosure? hire the guardian ad litem, do the newspaper, try to get an independent investigator and find everybody, and just move forward that way.
What's the typical cost to do the guardian litem? What additional guesstimate, right? That if we're going through a foreclosure on an estate, what's the time and the cost estimated for this process? Because as investors, we don't want to do any extra work, any extra expense in this foreclosure process. We rather foreclose on somebody who's living than someone who's dead. What is the extra time? Is something that in conjunction of what the time frame with the court already, or is it like we're pausing it, I have to extend it, and I'm spending $2,000 to do this, plus I'm losing another month?
You never know. That's the thing when it comes to doing it with deceased. Anytime I pick up a case in a quiet title or a partition lawsuit, anytime I pick those up and there's deceased, missing, or incompetent people, you have unknowns. You have unknowns on how many people you're going to find. I even had the unknown in the 40 defendants. We didn't even know about 13 more until the title company sent us another document from a trust. Wow. And all it took was another email. So, if you're in the game for this, you have to expect the unexpected. And I think that applies to costs and being, you have to realize that the costs and the services to do these things are to help things later on down the road, that you want to dot your I's and cross your T's, get all your ducks in a row. But, I always say when you're getting in the game of those quiet titles or even foreclosures, I'm sure people have seen, they could end up being 3,000, 6,000, 9,000, maybe, uncontested, even higher when you have those deceased people, because, guardian ad litems in Florida for doing those cases could be $400. Opening the court file could be $400. Doing a newspaper publication is like, I've seen them go to $1,000 before just with 4 people on it. So you're talking like cost alone, ready 2,000, maybe 2,500. We haven't even talked about attorney's fees and costs. We haven't even talked about service of process. So my point is that you got to be in it. You got to be in it to have a range, so 5 to 15,000 could be, 15 is probably a little high, but still it depends on how many people and the timing. Timing could depend on whether the judge tells you to go back and go reserve, whether they say go do the newspaper publication, whether your process server is taking a long time or can't find anybody. It could take a year. I've seen my fastest quiet title was 45 days during COVID. But you know what? Guess what? You both nailed it before. They were alive, right? The longest one that it's ever taken me on a quiet title has been a year and 2 months, because everybody was deceased and there were like 9 kids, 10 kids, and one filed an answer, never heard back a thing. And of course that changes everything, because now we got to set it for hearing, and it just changed everything. But the world of due diligence is important when it comes to all of this stuff, whether it's asking who the heirs are, or even on the foreclosure side or quiet title side, because you got to get as many people that are known that you can find, so you can move forward.
And I totally agree with you, right? But if I'm looking at 10 assets, right, and 2 of them are deceased, and one asset may have $20,000 balance on a loan, and I want to estimate my foreclosure costs in this situation, I understand we don't know, but if I'm looking at a $20,000 balance on a loan, am I really going to sit there and pay an extra $5,000 on top of the 6 for foreclosure and being into it for $12,000 on a $20,000 note that's probably going to sell at auction for 25?
Maybe not, but that's why I'm thinking that you look at it at a different angle of a real estate investment. Yeah. That way you're not spending that kind of money if you can find the heirs on a foreclosure or something like that. If you can find a way that you can actually buy the property and make that person whole, make yourself whole, right? So if you're buying that, let's just say you're buying that note or debt at 50,000, but there's a ton of more equity, and now you're not only buying the debt as a first position, you're buying the property.
Yeah.
I mean, so maybe
that's a key on this whole situation, right? If we can buy deceased property, deceased borrower's property from the heirs, and remove our first position, it's always a golden parachute.
Yeah.
But we're hoping that person is competent and is okay. I mean, I have the deal, one of our deals in Alabama, the property worth $170, right? My balance is less than 30 on it. So, I'd love to go to there and go, listen, I'll buy it and rent it back to you for less than you're paying me a mortgage payment. Right. But the problem is that I don't want, a lot of this stuff is I'd buy it to flip it. Right. I don't want to rent it to the heirs. I don't want to do anything. I don't want to be the landlord on the situation. However, yes, you're absolutely right. Because the borrower situation, the heir situation. Hey, listen, why don't you sell the property? Why don't you sell it to me? Right. And make the deal happen and we go away. Everything's good. But at the same time, they can sell the property. Right?
Sure. They could absolutely, you can line them up with a buyer. And what I'm thinking, David, is even if you're the one that's seeing it from an investment angle, even if you're first position, you don't even have to keep it. You can assign it out.
Yeah.
I mean, that's what's crazy about it, assigning it out. And then you, not only do you collect on your first position, you collect on the assignment fee. And now you just made more off that than you did holding it for 5 years, maybe.
Yeah.
Yeah.
Interesting play. For those who are listening, I definitely think that people are going to start looking for, estate sales and going, all right, Facebook, who is this person? Who is their kids, right? Hey, please don't go on social media and try to find people's heirs before you bought the note. Please don't reach out to these people. You don't own anything, right? You can come at it the fact that you found out that there's a cease to the paper if you want to do that. But if you're looking at a loan, don't let anyone know that you are doing due diligence by reaching out to them because you're looking at a loan. So, because you did sign a non-disclosure when you did it.
Yeah, that's big. No, cannot violate privacy, all that kind of thing.
Yes. There's no debt. There's no nothing. You don't know who the borrower is. You just want to buy the property. You can go that direction. And that's it. Al, I know you're only in Florida. Does the laws change a lot from your understanding from state to state? Is there big swings of different information?
So I could say that I know a few attorneys in other states that go through probate. One is Rylas Dana. He's in Arizona and he's an attorney also in California. And I actually just saw him in Arizona for the first time when I was there. And we were talking about timings of how long probate is there in California. And he's like, it could be 14 months, 15 months. And that's being generous on a probate in California. And, it sounds like Arizona's got like a tiered system of like, what Rylas calls mini probates and then probates, and then different systems of like, affidavits and different probates. So apparently Arizona is a really good state for probate also. So you definitely got to check out Rylas. He's all over social media and everything. But even Texas, we've heard that Texas apparently has a way that you can avoid probate if you have all of the heirs on board and they all sign an affidavit and a questionnaire, and then therefore you don't have to go through everything. So I know Nathan was talking about that on the show, like blew my mind away about Texas foreclosures. I was like, this is fast stuff.
Lethal injection.
This is fast stuff over there. There's a couple people that are doing, interesting things in Texas in that market, but North Carolina too. I've heard that if it's been more than 2 years date of death, that you don't have to go through the whole probate thing. So every state is different when it comes to this. You just got to really connect with professionals that know what they're doing in that state, that don't even just see probate, they see the real estate too.
Yeah.
Right. Like I don't look at it as just probate. I see a closing. I see a mortgage. I see options. I see weird and different stuff daily.
Gotcha. With that, so probate, Robin's coming in here that, you can avoid probate in Texas. But Texas is one of the worst when trying to find their heirs. Thank you, Robin. Yeah, I can imagine, especially with just what's going on in Texas, everything else. There's a lot of stuff going on there. Cindy commented